If you love liberty, declare your independence by signing the Shire Society Declaration at shiresociety.com.
This is case 2015-0720, City of Keene versus James Cleveland et al.
For the sake of folks who are in this morning's lineup, just so you know, we have 5 cases scheduled for the morning session, and we will do 3 without a break and then take morning recess to be followed by the final 2. Counsel?
Good morning, Your Honor, Justices. May it please the Court. I'm Robert Dietl on behalf of the City of Keene. I've asked to reserve 2 minutes this morning. The trial court ruled that any injunction of any distance would be unconstitutional in this case because it would have a significant impact on the methods used by defendants to disseminate their speech. The court effectively in doing this ruled that an injunction is per se unconstitutional if it will have a significant impact on speech. This is problematic for several reasons. One, injunctions almost always by their very nature have a significant impact on speech. And 2, it's not the law that has emerged from the United States Supreme Court. And 3, the finding that this will have a significant impact is inconsistent with the trial court's own factual rulings.
Which ones?
The court found that the defendants frequently videotape and follow 10 feet away. It found that they have a series of actions that they wish to engage in involving talking, videotaping, saving cars from tickets. All of those things are in keeping with the city's request for a 10-foot injunction.
But how can that, I'm just trying to imagine how this could happen. As I understand it, what the protesters want to do is they want to sort of follow it generally, and maybe they could do this from 10 feet away. They want to sort of follow generally one of the meter people. And then when they see that person is going to go to some particular meter where it's in violation, they want to then get there first. And it seems to me that there are going to be times when they're going to get there pretty close to each other. In fact, isn't there something in the record that at one point one of the protesters actually did put his hand or her hand on the meter reader's wrist?
Yes, there was an instance where I believe it was Defendant Graham Colson had a physical exchange with one of the parking enforcement officers.
But that's an assault. That can be handled.
That's an assault, and while we think that's indicative of the types of problems that can emerge, that's not what I think the core problem is here under the standard review before the court. The factors that Justice Lynn you were describing, those relate to the burden on the defendants. Now, the trial court denied injunctive relief here because it found that it was a significant burden.
May I ask for a clarification? We have a video as part of the record. I have watched the video, and I believe several of my colleagues have. Would you agree that what is on the video is fairly representative of what was going on? So was that an unusual video, or do you acknowledge that it was representative of actually what was happening?
In complete candor, I believe that it was representative of how things can boil up.
Okay.
That not necessarily was their daily interactions like that.
Okay.
But that's precisely the type of conduct that we want to avoid.
But you know what, if you're saying that that's an example of boiling up, and that normally it's even less than that, I have to tell you that I looked at that video, and I was not impressed at all that the protesters were in some way doing something that they should be enjoined from doing. I mean, to me, as I looked at that video, the most salient point about it was this other woman who was not the meter reader, who was walking by and basically blew off the protest. Say, get away from me! What are you doing? She didn't seem to be intimidated at all, and candidly, as I looked at it, it seemed to me that the meter reader, who it seems to me that she's not a police officer, but she's in a line of work where she at least needs to expect that she's often going to be not delivering good news to people by giving them a ticket or whatever, and some of them are not going to be particularly happy about that. maybe she needs to, for lack of a better term, maybe she needs to sort of toughen up a little bit?
Well, my reaction is that I think it's an unreasonable conclusion to view that in isolation. We're dealing with 3 years of conduct here.
Well, but you say, you were the one that said in response to Justice Conboy's question that is sort of a boiling up. So that suggests to me, at least, that the sort of more routine things are less than that.
There is a routine aspect to this, which perhaps if you view these individual incidents in isolation, they might not be all that bad. But on a regular, recurring basis for 3 years, and the trial court finding that this was still going on, and that's an important point. The trial court found that this was still going on by at least one defendant several days a week for several hours, and I believe the actual trial testimony from the defendant was 3 to 4 days a week for 3 to 4 hours.
But with
So
far
there's
less intensity. I'm sorry.
a general diminishment of the activity over the course of time. It sounds as though they're all getting a little tired of it for the most part.
Well, there is a change, but I think the core question before the Superior Court, it's really 2 buckets. Has the city proposed a constitutional injunction? It has. I don't think there can be any reasonable debate on that. And the reason why is because we have clear decisions from the Madsen case in 1994 and the McCullen case in 2014.
Isn't there a big distinction that those are buffer zones at a sort of stationary place? Here, you're talking about, as your opponent points out, you're talking about trying to impose a buffer zone on literally what is a moving target, which is the meter enforcement people.
There is a moving target, but these are more narrow actually than those cases, because those cases could apply to anybody entering certain areas. We're talking about 2 individuals, and we're requesting relief that's directly in line with the directions from Justice Roberts. Justice Roberts said injunctive relief needs to be pursued. That's why the McCullen case was overturned. The Commonwealth of Massachusetts did not first pursue injunctive relief, and Justice Roberts admonished them and said, you need to look at this. Injunctions look at the precise conduct by precise individuals, and they get at the core. That's more favorable than broader prophylactic measures like an ordinance or the ultimate chilling effect, an arrest.
Is it irrelevant that an individual meter reader might have the ability to seek injunctive relief personally, alleging harassment or some other criminal offense?
From the standpoint of the city's interests, I think it is. And the reason being is that the city needed to show to the trial court, and it did, that it had proposed content-neutral injunctions that were constitutional. We know this because the trial court ruled they were content-neutral. It ruled that there were significant governmental interests. And not just that, it ruled that they were ongoing significant governmental interests.
I take it there hasn't been any individual request for injunctive relief?
There is not at this point, Your Honor.
Okay.
Am I correct in understanding that the city is not trying to stop the feeding the meters itself?
Precisely. The injunction the city proposed, and this was the 3rd finding from the trial court, was what the trial court described as the most narrowly tailored that it could conceive of to provide any meaningful relief. Those are the prongs that the city had to satisfy from a
Let me just ask you this then. How, when you say, and I think your opponent, if I'm remembering correctly, raises at least some question about this. When you say this is content neutral, if I'm understanding correctly, your injunction would not apply. If I happen to drive over to Keene and I parked and I stayed over suppose I put in enough money for an hour, but I stayed an hour and 15 minutes. And I realized, oh geez, I better go out there and put some more money in. And I went out while a meter reader was walking in the area. Would I be subject to the injunction?
No, you would not.
Okay, so it sort of depends on whether on what the purpose is, isn't it? I mean, if I'm a protester, then I'm subject to the injunction, but if I'm not, then I'm not. Doesn't that suggest that maybe there is some content to this?
No, respectfully, Your Honor, it does not. The testimony before the court from the parking enforcement officers is that they would have problems with this, and I think rightfully so, even if somebody was coming up to them every day. It's the frequency aspect of this that is particularly troubling, and getting in their face and saying, great job, you're doing a wonderful job, but following them every day, this close, day in and day out, emerging at times that they can't anticipate or expect, getting in their way when they're trying to get to meters, those impair significant governmental interests that the trial court recognized. And the problem is that the court finds that there are significant interests in play. It finds that each of the elements that the United States Supreme Court requires are satisfied. And then it says, but I can't grant injunctive relief because it would place a significant burden on the defendants. Well, that's going towards a strict scrutiny test that the Madsen court expressly reject. The Madsen court looked at this and said, Justice Scalia wants us to impose a strict scrutiny test when we look at injunctions. We're not going to do that. Strict scrutiny would require a compelling governmental interest, and that these are the only way to satisfy that interest and protect it. And they expressly adopted an intermediate standard. And that standard looks at what the burden is. And that's important. There's always going to be a burden when there's an injunction. And if the court denies injunctive relief here because it says that there's a burden, well, is it truly a significant burden? I don't think when there's adequate alternate channels for communication, when they can talk.
What is the harm? I guess this is what I'm having real difficulty with. What is the harm of that is, to the parking enforcement people that they are suffering at the hands of these protesters?
Well, the parking enforcement officers have sought counseling, and there was testimony in the initial hearings of the stress that they are under that was uncontroverted, and that the city has a significant interest in making sure that its employees are mentally healthy on the job so that they can actually go about doing their job.
I agree with you, and I don't mean to be callous, but isn't part of their job description a warning that they may be subject to certain difficulties on the job because of the nature of their job?
Yes, Your Honor, it is, and that contemplates individual interactions with individuals. It doesn't contemplate years of recurring, ongoing conduct. It doesn't contemplate having people wait outside the bathroom for you. That is something that at some point is going to wear down individuals. It's therefore going to impair the city's interests. And because the city has articulated those significant interests, the court should not, as a matter of law, deny it on constitutional grounds and say,
So it's the mental health of the employees that's the significant government.
that is one of the significant interests.
Name another.
Public safety and keeping the civility on the streets, that's expressly recognized.
It sounds a little vague to me. What do you mean, public safety and civility?
In the video that was provided to the court, we have an evidence of an individual who comes in because she's seeing a PEO being what I would describe as harassed, and she inserts herself between the PEO and the defendant. That's one example.
You mean the young lady on the video?
Yes. And in the initial hearings, we had evidence of a fight where one of the members of the public chased the defendants through a parking garage, screaming and threatening them.
But
That's
of course,
public order.
those people would be able to bring private complaints for protection, right?
The individual
Individuals.
public citizens
Yeah.
or the parking
The
enforcement
people who are
officers?
chased. You said in a parking garage, didn't you? just say that?
Who was chasing
Yeah,
who?
yeah.
Who was?
Yeah, there was a member of the public chasing a defendant.
So it was. So
Oh,
isn't,
okay, I misunderstood.
Right. So isn't that? I mean, isn't there some case law that says the fact that some people may react themselves illegally because they don't like what you're protesting doesn't mean that's a reason to stop the protest?
No, it's not. And I see my time is up. I'm happy to address your question if I
Well-
may. The interest here is one that's been recognized in numerous cases by the Supreme Court. Peace and order on the streets is a significant governmental interest that the Supreme Court has held warrants injunctive relief.
May I just follow up, even though
You may.
time? I don't mean to personalize this, but I'm trying to press where the outer limits are. A million years ago, I personally served in the U.S. Air Force during the Vietnam War. If I wore my uniform and walked down the streets of Boston, I was harassed, called names, whatever. Would there be sufficient governmental interest to give me a zone, some kind of zone of protection as I walk down the streets of Boston?
Under the hypothetical you've set forth, I would say no. But I don't think those are the factual circumstances that we're dealing with here. Because
The harassment was pretty severe. There certainly was more so than I saw in the video.
It was, and individuals in service at that time certainly encountered recurring harassment. But these are two individuals facing recurring harassment for 3 years, every day when they go out to work, or almost every day now, by discrete individuals. That's something that can be enjoined and should be enjoined.
Thank you.
Yeah.
Mr. Meyer?
Thank you, Your Honor. Madam Chief Justice, may it please the court. I'm here representing the two remaining defendants in this case. Again, my name is John Meyer. This court is being asked to do something which, as far as I can tell, based on my research, has never been done by any court. And that is to issue an injunction against a small group of political activists that covers the entirety of a essentially municipal downtown. I believe that is completely unprecedented. The closest case that either side has been able to come up with are the line of cases involving abortion clinics. And the crucial distinction there is twofold. First of all, they only involve a tiny sliver of the downtown, just the area right around the entrance to the clinic.
Can you give us a clarification? I'd like to have your answer to the question that I asked your opponent. Does that video fairly represent what went on routinely?
No, Your Honor.
It doesn't.
And let me just, a couple of responses, I think that's an important question, because it really goes to the decision of the trial judge. The court came back and said, in terms of remand order to the trial judge, we want you to look at the specific factual circumstances and anchor your decision in that. So the court then held another full day of hearing. Now, that day of hearing came 2 years after the first 3 days of hearing. And it was clear, as the trial court made evident, that the situation had changed dramatically.
So was that video, when was that video taken? When was the video taken?
The video would have been taken sometime between the first hearing and the second hearing.
Okay, so
the video was presented at the second hearing.
Okay.
Now, the reason, Your Honor, why I don't think it's particularly typical is that the video, there are only two remaining defendants who still do any Robin Hooding. One of them is Mr. Freeman. The video is of Mr. Freeman. His testimony is that he, in the 2 years in between, he'd only Robin Hooded twice. So this was one of 2 times in over 2 years. Now, the parking enforcement officer who was asked, I think, put it as somewhere between, 10 and 20 times maybe, or a half a dozen, a dozen. But in any event, it's clear by all accounts that Mr. Freeman is Robin Hooding no more than once a month. So for that reason alone, it's not a typical scenario, because there's no claim. The other thing is, in the remand hearing, there was no testimony that any current Robin Hooder ever got too close to any of the defendants. There was no any of the parking enforcement officers. There was no testimony that they intruded in personal space except to pass. There was no testimony that they were ever asked to step back. So now this is admittedly contrasts dramatically to what was occurring 2 years before. The only Robin Hooder who was engaging in Robin Hood activity in any frequency at all was Mr. Eames, and according to the trial court and according to the witnesses, his presence was described as being unobtrusive. He was the one Robin Hooder who was described in the first set of hearings as being respectful. And he testified without contradiction that he maintained.
So at least part of your position is factually,
yes,
the situation changed.
Absolutely, and I think, Your Honor, that was critical to the trial court opinion. And I think, again, when this court said equitable discretion, it made clear that the judge was supposed to exercise his discretion based upon the particular factual circumstances.
So if the circumstances had remained as, for lack of a better word, intense as they had been 2 years earlier, the trial court might have been justified in enjoining some of that conduct.
Well, Your Honor, I think from a First Amendment point of view, I would still think that would have been unconstitutional. But from a point of view of exercising equitable discretion, which is, I think, where all this, much as I would love to talk about the First Amendment, I think the trial court was looking at it primarily from an equitable discretion point of view, and I think it's clear that was a crucial factor, that he was. And the difference between the parties really at this point is the defendants want you to look at what was occurring years ago. I'm sorry, the plaintiff wants you to look at that, and the trial judge is saying, no, we need to focus on what's happening right now.
And the court, having exercised its equitable discretion and focused on the recent time frame, we have a very deferential standard of review at this point, don't we?
Absolutely, Your Honor, and I think that's a crucial point. The court has made clear that when it's a matter of trial court equitable discretion, it's not an issue whether the trial court was right or wrong, but whether the trial court exceeded the broad extent of its discretionary power or engaged in a mistake of law.
What was the strength of the evidence that the employees were seeking counseling?
Your Honor, Your Honor, 2 points on that. Your Honor, first of all, that testimony came in 2 years ago, or now almost 3 years ago at this point, the first set of hearings. And it wasn't that they were engaged in counseling. Well, the testimony was that the city hired a counselor. City hired a counselor to talk to them. However, all 3 parking enforcement officers testified that they did not themselves go to an individual counselor. So there's no testimony of any need for individual counseling. What their testimony was the testimony of the fact that the city retained a counselor to meet with them. But, Your Honor, that goes, I think, to the point that was raised earlier in question to Attorney Dietel, which is even this court said in the remand that the issue here is it should be, for the trial court, should be a matter of public safety. And I certainly agree that public safety is a fundamental interest. But there is zero evidence at any point of any public safety issue, except, as Attorney Dietel said, on a handful of scenarios where outsiders attacked Robin Hooders. And again, none of that had occurred within the last 2 years, but in an earlier time frame it had occurred that had raised some public safety issues. The PEOs are members of the police department. If they need help, they testified that their protocol was to go to contact the police department. I asked them, did you ever go to the police department in regard to Robin Hooders? The answer was no. Now, in the most recent, except for the third-party assaults, in the most recent scenario, one of the PEOs testified that volunteered that there were 2 scenarios which made her upset. Both of those scenarios are cause for apprehension. Both of those scenarios involve people who are not defendants, either originally in this case or currently in this case. And what she said was, these people, I didn't know them. I know the Robin Hooders. I don't like the Robin Hooders, but I know the Robin Hooders aren't violent. These other people came by, didn't know who they were. They yelled at me, and I really was apprehensive. So, in fact, the testimony is that my clients are not causing any public safety issue. But the concern is that if you issue an injunction, then the crosswalks are only 5 feet wide, according to the testimony in the hearing. So they can't come within 5 feet. They're going to have to be outside the crosswalks. They're going to have to jump off the sidewalks. The concern is...
Are you saying this is no longer a First Amendment case?
Well, I don't think I think it is a First Amendment case, but I don't think it's necessary to decide this case on the First Amendment basis. I think that equitable facts that will govern the trial court's exercise of discretion are sufficient to support the trial court ruling. But, there is one point I want to make which sort of relates to the First Amendment and also to the equitable discretion, and that goes back to what Attorney Dietel said earlier, because it's a somewhat subtle point. And this has to do with the McCullum case. And his interpretation was that McCullum says it's better to have an injunction which is narrower than to have a broad-based ordinance. That's not what McCullum says. McCullum says there's basically a hierarchy of 3 types of approaches. The approach that's most preferable from a First Amendment perspective is a generally based ordinance, because that only punishes conduct that violates the ordinance. It doesn't target anybody as a prior restraint. So the preference is to have an ordinance across the board. Only if that fails, and in McCullum what happened was you had an ordinance that led to a number of arrests because it wasn't adhered to. Only if the ordinance fails do you go to the next step of considering an injunction. And one of the things the trial court said in this case is the City of Keene has a host of other options here. It has the ordinances it can enforce. It has the rights, ordinances vis-a-vis public areas. It can adopt new ordinances, which would apply to everybody, but wouldn't cover people. It would cover conduct. It also, if there's any violation of the criminal law, there's the right to enforce under the criminal law. So the court said a far less restrictive way to address this vis-a-vis the First Amendment is to enforce the laws that are there. And if the local ordinances are not adequate, then to apply an ordinance that applies across the board. Essentially, what this is about is the right to be left alone. Now, in the Doyle case, this court said, strongly questioned whether the right to be left alone was of constitutional, was of compelling or even substantial government interest. The Doyle case being the one up in Mount Monadnock. And then more recently, the U.S. Supreme Court really followed that theme in McCollum. McCollum said the whole point of public sidewalks in the First Amendment is the ability to give unwanted messages to persons who don't want to hear them.
I mean, it occurs to me, Mr. Myers, that if we were to agree with your opponent on this, would that mean that, for example, let's say in Ferguson, Missouri, after the shooting, that the police could get an injunction against protesters who were not ones that were doing anything violent, but simply because they were, walking up relatively closely to the police and they were angry, but let's assume they were not doing anything violent. I would think it would be pretty hard for the police to be able to get an injunction in those circumstances.
Well, Your Honor, I think it should be, and that's exactly the problem. Even whether or not there's a right to be left alone, which I think McCollum really questions in terms of public sidewalks, that right should not apply to public employees, because then for the reason that Justice Lynn raises, because that really cuts at the heart of the First Amendment. But the other point here is the real concern, if you look at the testimony, is not the proximity, at least not certainly recently. The real concern is about what my clients were saying. And the parking enforcement officers made it very clear that they found what my clients were saying to be obnoxious. And maybe, depending on your perspective, maybe what they're saying could be interpreted to be obnoxious. But again, that goes to the heart of the First Amendment. And this court, in addressing these type of cases, have really required that things be narrowly tailored, that there be narrow tailoring between the restriction and the state interest. In this case, it's the opposite of narrow tailoring. First of all, it only applies to 2 individuals. So out of all the people who might engage in Robin Hooding, only 2 people would be prohibited. Everybody else would be unaffected. So that doesn't protect the parking enforcement officers.
I guess I misunderstood the city's request. Did they really request that it only apply to those 2 individuals
only
as opposed to a class of individuals?
Right. They've never asked for a class. They started off by asking for 6, Your Honor, and now it's been reduced down to 2. But there's never been a request beyond those 2. And the other way in which it doesn't serve the interests that are stated is the parking enforcement officers have made clear that what they really are upset about is what's being said to them. Now, it's true when they're asked leading questions, would you rather have the demonstrators stay further away? The response to that has been yes. But the core concern, which has not required leading questions, is we don't like what they're saying to us. We don't even like it when they ask us what the weather is. And that, again, is whether you sympathize with their feelings or not on this, that is core speech. And that's what is, if the injunction were to be granted, what would happen is that my clients, instead of being able to engage in conversation, would have to yell from a further distance away. And again, going back to Justice Roberts in the McCollum case, that really goes to the heart of the First Amendment, the capability of delivering an unwelcome message to somebody on a public street. That is where the essence, I think, of the First Amendment lies, and that's why I think the trial court properly avoided the constitutional problems by making a ruling based on equitable discretion. Thank you, Your Honor.
Thank you. Anything to add, Mr. Dietl?
Just briefly, Your Honor.
Okay.
A lot of what we heard from Attorney Meyer is attacking the significance of the government's interests. That's not genuinely in dispute, nor was it challenged on appeal. The trial court found that the city has ongoing significant governmental interests. And so the error that we think occurred here is one of law and one of fact. The court applied a standard under constitutional law that does not exist. It found all 3 criteria to determine that these injunctions were constitutional, and then imposed an extra analysis. So to the extent that the court denied relief on constitutional grounds, that's not sustainable. That is an error of law. So the only other way to look at this is to say, well, did the court have a valid reason to deny this just as an injunction generally? And it doesn't. There is an irreparable injury here. The defendants would dispute how much the injury is, but there is an injury, and that's been recognized by the trial court.
What is the irreparable injury?
We fully expect that this is going to bubble up and continue, and that we can't know exactly what the consequences are, but the 2 remaining parking enforcement officers were once 3. One has quit. And part of the reason why we believe that the parking enforcement officers are still there is because they've known that the court is looking at this. We don't know if they're still going to want to continue to work under these
But
circumstances.
isn't that, I mean, but isn't there something to the fact that they, this is sort of inherent in the job? If if a police officer said, geez, I don't, to go back to the Ferguson example, I don't like being on the street, protecting businesses or whatever when there are angry people that are out in the street protesting. Would we say that's a reason to grant an injunction against the protesters?
Respectfully, I think Your Honor's comparison is not directly on point here and not applicable. And the reason being is that what you're describing is individuals there, an expectation that as a parking enforcement officer you're going to encounter hostile people. We're dealing with 3 years of ongoing conduct by specific individuals. I think that has a markedly different character and impact. But the court, and I see my time is up.
You can finish your sentence.
The court also denied this because it found factually that there was no significant impact, that there was a significant impact. I think if the court looks at the factual findings that the city has requested a 10-foot separation and that this can all occur at 10 feet, that there is no significant impact. Thank you, Your Honors.
Case submitted. Counsel may come forward in the matter of
features
State
audio,
versus
video,
Robin.
and blogs chronicling the transition to a voluntary society. FreeKeene.com also has comments and discussion forums so you can be heard. FreeKeene.com.
I should be in Keene, New Hampshire with the Free Staters.